I have the clicker in my pocket. I needed to get something to drink.
Sure. Yeah. I know, right? Look at this turnout. Ready to go?
You have a whistle?
Not on me. It's all right. I've got a good drill sergeant voice too. Good evening, everybody. Please continue to eat, continue to grab food if you haven't yet. Again, my name is Chris. I'm one of the chapter officers for ISC Squared. Welcome to the October meeting. Welcome especially to the IAPP crowd. Tonight's topic is really around privacy, and that, as I understand it, is really your bailiwick. So we look forward to the interaction and the conversation there. If we get the next slide. Possibly. So the agenda generally is going to be just this quick intro, the panel. If at the end we've got a little bit of time to go once around the room, we will. But we do have a full panel tonight. We do want to thank our sponsors as well. Obviously Kaplan for hosting us, that's great. Places like Tyler and Sage do a lot to fund what we have going on. Peter himself actually put himself out for the food. We're going to do our best to reimburse him, but thank you very much, Peter.
My boss put himself out.
His boss did. All right, we'll clap for your boss. And of course, Kaspersky Lab and Cyber SN. There are a couple different sign-in sheets. There's an IAPP one and an ISC Squared one floating around. I'm sorry, both at the table now. So if you are looking for CPE credit, please be sure to sign in. If you do need a copy of that, please ask one of the officers and ask us in a short term. Please don't wait a year and say, hey, can you send me a record of what we've done or what I've attended over the past year. That is a tough hill to climb. So snack presentation, that's about what we have. Unless there are any questions for me, Peter, I'll hand you the microphone, and you can start walking through the presenters.
And they're a part of this?
Yep, they'll be right. Nope.
Is there another deck? Yeah, we'll start with this. I don't know. Okay, well, we'll do some quick introductions first. I'm Peter Higgins. I'm the security officer at Tyler Technologies. Afterwards, we're going to have a panel, so I'm going to ask them to raise their hands. We have Catherine Reed. We have Jeff Northrup from Liberty Mutual. We have Peter Guffin from Pierce Atwood. And we have Abby Diaz, who is the Associate General Counsel at Tyler Technologies that I corralled to come help me defend this. So again, Peter Higgins, I've got up there the 3 certification groups that I participate in. This is the ISC Squared chapter. It's 5 years old, formally, 4 or 5. One of the founding members. I'm also a member of the IAPP, so I have my CIPP for the U.S. Law and Regulation, and also with ISACA, which is the Audit Assurance side, so I have a couple of them. And for the lawyers, I have a disclaimer in here that these are my views and not those of the company. And I also want to make it clear that of all the certifications I had, it was the privacy one that gave me the most heartburn. So I've got a number of slides. I'm going to go through and talk about what I see as the problem space that we're dealing with here. The official title of this is the legal, privacy, and security issues in procuring and offering cloud services. So we'll cover a little bit on that space. We'll cover a little bit on the contract language, and then the team asked me to spend a little bit of time on talking about what controls, control frameworks, sort of IT speak, because many times it's a language issue as much a technical issue. So I'll cover that. So this is a test. You've just got an RFP from a client. You have 1 minute to review the language before the call. And here it is. There are 54 numbers on this chart. You have 1 minute to find them all in order. Nope, we got 5 seconds. Okay, time's up. Show of hands, there's anybody who's found all 54 of them in order? Okay. We'll get back to this a little bit later. So I'm going to talk about the problem space, and one of the things that we talk about is just the sheer magnitude of the environment that we have to operate in. So when I'm talking about how quickly technology has advanced, this is a story that I share with my kids and with my friends. There is a Hindu folktale about 6 blind men and an elephant. And depending on where you stand and what your perspective is, and if you look at it, one has a tail, one has a side, one's got a leg, one's got the ear, one's got the tusk, and one's got the nose. And to each of them, it's something different because of where they're at and what their perspective is. And though each were partly in the right, all were in the wrong. So I use this as an example to talk about when we are communicating with our clients, trying to determine what they need for cloud services. The biggest challenge is to start with where are they coming from? What's their perspective? At Tyler, we have this confusing intersection of overlapping standards depending on where our clients are coming from. Tyler Technologies, our marketing position is we're the largest company in the country whose sole purpose is software and service for the public sector. So if you think about it, we provide software and services, what we call cradle to grave, and public safety, courts and justice, schools, students, and everybody's coming in with a different perspective. And we are challenged to try to help them navigate this. I tell the story of basically how quickly technology has advanced. My grandmother came of age was the time of the Wright brothers. When my parents came of age, it was the Depression and World War II. When I came of age, my uncle, who was my grandmother's oldest son, worked for Grumman Aerospace, lived in Houston, and worked on the Apollo mission program. So I kind of think about, my grandmother at 14 was, seeing airplanes fly for the first time and lived long enough to see man on the moon. 1977, I graduated from college. The movie Star Wars came out, and there was this little networking thing called the ARPANET, the foundation for what, the internet today. And if you look real close, you can see the NSA is on there. So even from the early days, they were involved, and they were doing satellite connections to London and to Hawaii. When my son turned 14 in 1995, Windows was released, Netscape, internet browsing, and when I was at Liberty Mutual, I was on a project. We were doing what I would consider sort of the foundations to sort of big data. We were running a process on an Apple Mac that was doing benchmarking against an IBM mainframe running Teradata. So this stuff, big data and cloud, and has been around. Today, a visual representation of the internet, it's just huge. It's hard to kind of wrap your head around it sometimes. And when we're dealing with clients, they look at something like this and go, well, where's my stuff? And what are you doing to protect it? 2008, the estimate was we now have more endpoints on the internet than we have humans on the planet. And by 2020, they estimate there'll be 50 billion endpoints on the internet. And I can manage my washing machine from my smartphone if I so choose. Do I need to? Not necessarily. Now I'm going to jump into the control frameworks, and I call this my sort of the triplet. So this is a topic that anybody who sat through any one of the 3 certifying groups, there is a common theme of controls and frameworks that they speak to that help you kind of build the constructs around how to learn the material. So we'll start with just a dictionary definition. You know, we've got the controls. Anybody who works in a business, anybody who works in finance, there are the controls we put in place, our accounting systems, our HR systems, our security systems. What I want to call out on here is we're calling out the following categories: how effective and efficient the controls are, how reliable they are for the financial reporting, and are they compliant with applicable laws and regulations. Now, if we roll up to the second paragraph, we have reasonable assurance that we're representing it accurately. And if we roll it up even further, it goes up to the board. And our argument is that ultimately the board of directors has the fiduciary responsibility to make sure that we as professionals are accurately representing our controls. And if we all think back to the reason that we have Sarbanes-Oxley or the SOX 404 audit, where the likes of Enron and Tyco International who materially misrepresented their financials. So I ask, like, what is a framework? In its simplest form, it's just a basic structure that you can use to define the controls that you need in place. So we go back to our little exercise at the beginning. If I told you that all the numbers were on a 3x3 grid, there were 6 numbers in a box, and they were in order, then we could go through the same exercise again, and I could almost, I guarantee most people would be able to find all 54 numbers in order, within a minute. Where the controls come into play is when we're dealing with RFIs, RFPs, and the contract language. And this is one of our challenges that we have is when the clients don't know what they need, they tend to ask for everything. And they ask it, please protect my information, the confidentiality, integrity, and availability using security and technical controls. Now, how I, sort of a sidebar here, when I took the position 4 years ago at Tyler, I sat next to our contracts group, which is how I met Abby Diaz, because they would come over with these questionnaires that they were getting from clients, and many times you could tell they did a Google search and they asked for like everything because they didn't know what they really needed. Or they would hire a consultant who would come in and overwhelm them with detail so that they could run it, earn some business. So we'll cover a little bit on what these controls are. Different levels. Here's one that is a policy that we were being asked to follow for an on-premise install. And it was, you must exercise all reasonable safeguards, but we can't tell you what they are. But if you don't do it right, then it's grounds for appropriate legal action. I don't know that we signed off on that one. If we take it to the next level, here is a single paragraph from an RFP dealing with loss of data. And what it talks about is it's got some information there about the security, the confidentiality, and the integrity, do these physical, technical, administrative safeguards, and they repeat it, and then something about PII in there. But they wouldn't tell us what PII was, and in their case. This is a recent one that came through. This was paragraph IS 18 on page 15 of a 33-page appendix dealing with a cloud service provider, asking us if we did identity-based encryption and multi-tenancy. And our argument is we're not Amazon or Microsoft Azure, and we get hung up on these kinds of requests and this kind of language because the customers, A, don't know what they need, what they want, and we're challenged to direct them and guide them through the process. So we'll start with all three certification groups have a foundation, what they call the CIA triad. And it's the idea that you could put any one of the controls in this context of what it's doing to protect the confidentiality of the information, that only those people and processes that should have access to it have access, the integrity of it so that it's not changed inadvertently or intentionally, and it's available. So you can use this framework, and basically the IC squared, the IAPP, and ISACA, all their information flows down from this basic fundamental foundation. My little study guide was to learn these acronyms of the physical, administrative, and technical controls. So physical are things like doors and locks, administrative things like workflows or training, and technical controls, so things like encryption keys and databases. From a security side, we talk about preventative, detective, and corrective controls. So basically stopping something before it's compromised, being able to tell when it has been compromised, so the detective, and then having something to fix it after it's been compromised. And the trick to the certifications that we go through is that what they'll do is they'll ask questions and they'll kind of mix in these kind of different terms, and then they'll throw in a kind of an outlier just to make sure you understand the material. So I kind of built it all up into a kind of like a Rubik's Cube thing that you could take any one of all three of these three triplets and use it to define the framework that you need to implement to protect a system or data. I'm referencing here a FIPS publication 199, Security Categorization Applied to Information Systems. It's all of 9 pages. And what it talks about is going through this exercise of determining what the security categorization is for a system or for data based on a function of the risk, whether it's a limited risk, a serious risk, or a severe catastrophic risk, to the confidentiality, the integrity, or the availability of that system or that data. And out of this flows all by categorizing a system, it then gives you input into following standards, particularly the NIST 800, that you need to put in place to meet this particular requirement. So in this case, if it's a security categorization of data that's got PII or PHI in it, is high confidentiality, it's got a high integrity, so the system would be categorized as a high, and how you can address this particular requirement is through the use of encryption. Yes?
In the chat box, you got a question.
Question is, how often do you encounter organizations that are oversold things they don't need from vendors because of things they don't know that they don't know? And how can one avoid that? I'm going to open that question up to anybody can help me on that one. Our particular case, we're selling cloud services to clients, so this is not, I can't really relate to this particular question to our problem space. I would say the one way I could answer it is we have clients who don't know what they don't know, so they hire a vendor, or they hire a contractor, or they hire a consultant to come in and help them navigate this. And I had one where I was on a call where the client didn't know what they needed, so we were dealing with the consultant. We got into a 10-minute conversation around what multi-factor authentication was. And it was as much as he was trying to sell his service to the client, I think, as he was trying to help them. So I can't say it happens a lot, but it is an issue that we do have to deal with. One of the other sort of the IT terms that you'll hear is defense in depth. And the idea is that you need to have these security controls at every layer, all the ways from the outside of your systems to the data. And sort of the one analogy I can use is that we have a networking manager who talks about we're very good at putting sort of the hard outer shell around our systems and our data, and then we kind of forget about the squishy middle, he calls it. And so the point here is that sometimes we get this kind of a question in an RFI or an RFP asking about, are we ensuring that our controls are covering all of the different layers? We are here talking about cloud. So the Cloud Security Alliance has a finding that you can have all the greatest controls on the hard outer shell, but if you've got weak application controls, that's where your risk is going to be the highest. And I reference this as a sort of a hook into an organization called the Open Web Application Security Project, or OWASP. They have a framework that they call the top 10. And the top 10 are known application vulnerabilities that have been demonstrated and are been compromised, and 12-year-olds, it's to the point that 12-year-olds can buy tools to basically run these compromises against websites. And we've seen language in some of our RFIs and RFPs specifically asking, you know, are we conducting vulnerability scans based on the OWASP top 10? And you start asking them, well, which particular ones, and they just kind of went, all of them. So I kind of bring it in here just as an awareness for this part. This all leads into having a formal risk management process where you have to identify what are the assets you're protecting, what are the risks to those assets, and then what are the controls that you have in place. This is out of an ISO 20700 framework. Take it to the next level. It's actually going through the ISO risk management framework, identifying what are those assets that you need to protect, what are the threats to those assets, and what are the vulnerabilities. And then what are the controls that you put in place. And my deck just went cold.
This slide wasn't intentionally left blank.
No. Pardon?
Do you want your other file?
Yeah, I don't know what happened. for a page count on that? You bring up the PDF one.
Something going on.
Are we all set? So this is kind of like when you go to law school and you're doing your first presentation and they throw your slides on the floor. So we're going to talk about what the NIST framework around what they consider sort of the essential characteristics, the service models, and the deployment models. I'm going to power through this and make sure that Catherine gets her time. And I'm going to do it by hand. The 5 essential characteristics are, is it an on-demand service? What kind of network access do you have? Kind of resource pooling, and we hear the term multi-tenant. And is it rapid elasticity? So can it with basically automatic provision and release? And are you getting optimal or measured service, kind of like your electric bill? The 3 primary frameworks are software as a service, platform as a service, or infrastructure as a service. If you use, like Gmail is a software as a service, whereas in our organization we sell software as a service as an offering, so the client doesn't have to have anything on premise. The different deployment models, private, community, public, and hybrid. And I'd like to kind of give a shout out to Andy Smith, because I stole this from his slide deck. It was one of the first presentations I went to at Tilson back about 5 years ago. And we were talking about this before, that this stuff really hasn't changed that much in 5 years. And there's a whole conversation around how much of the stuff's really even changed in 20 years. I kind of cut my IT teeth on mainframe and then to client server and then into web stuff. And the stuff really it's not all that much different. So when we get into dealing with RFIs and RFPs, we ask, I kind of put up my 6 blind men and an elephant. I put up my controls. And the question is, our challenge is when we're dealing with clients is determining where we're going to draw the boundaries around what is our responsibility and what is theirs. And, I deal with the contract folks, and I'm constantly amazed on the back and forth, back and forth, back and forth. It goes, we're redlining and this and back and forth, just trying to get the particular language. The Cloud Security Alliance makes a statement that the lower down in the stack the cloud provider stops, the more security the consumer is tactically responsible for and implementing and managing. So as we're dealing with RFIs and RFPs around cloud services, I think you need to go through that exercise and spend the time to identify and articulate very clearly the language you're going to use, and where in this tier are you going to set the boundaries as to what you're responsible for and what the client's responsible for. I'm going to talk at a high level the frameworks that we deal with at Tyler and that lead into our cloud offering. We sell software and service in all 50 states, and in the absence of state requirements, they lean on the NIST, the federal standards. We are evolving on ISO 2700. We're going international. We are publicly traded on New York Stock Exchange, so we're subject to the SOX audit. We have a PCI enclave, so we go through payment application and credit card audits. We have a hosting operation, so we have elected to go through the AICPA and the SSA 16 audit for SOC 1 and for SOC 2. We sell education software and HR software, so we're dealing with HIPAA and we're dealing with FERPA. So when we come into where, the 6 blind men and an elephant, I sort of draw this picture that the box is Tyler Technologies, but I've got these different domains that we need to be aware of and manage expectations around. So on the left, I've got my financial audit bubble. In the bottom right, I've got my hosting bubble. The upper right, I've got my PCI space. And you'll see where they all intersect is around our employees and our developers. So kind of going back to that whole OWASP top 10 things, we could have all the controls in place, spend all the money in the world, but if our developers are not developing secure applications, then it's all for naught. So, and this is something that, as you're working in the security space, what they talk about is the weakest link is the human factor. It's our developers, it's our end users, it's the people who open that email, click on that link, download that PDF. We do have a success story at Tyler that one of our HR reps opened a help desk ticket. She had gotten an email from our CEO saying, I'm on, I've got this project, I want you to send me PDFs of every employee's W-2s as soon as possible. She hovered over the email address and it was janet88@verizon.net. And she goes, I don't think that's John Marr's email address. So she didn't do anything and she sent it to the help desk. Concurrently with that, one of the vendors that we deal with who are all technical fell for something like that. And now they're dealing with breach notifications to all their employees because they shared all their payroll information. So basically I'm going to wrap up with how do I try to make sense of it all, and I've used up my time, so I'm going to power through this really quick, make sure that Catherine and Peter get theirs. The SANS NSA Top 20 Security Controls, the NIST Cybersecurity Framework has a controls database, the Cloud Security Alliance Guidance, the Cloud Security Alliance Common Controls Framework, and an area that I'm just now getting into is a service called the Unified Control Framework, or the Common Control Hub. So I'm going to power through this. The SANS NSA Top 20 are the known controls that you can put in place to provide some semblance of security. What they talk about is it's a maturity model, so you can't put them all in place if you're a small business. So they say at a minimum, you should do antivirus, you should back up your systems, and you should do training. Once you go into the next level, you start at the top and work your way through, and you start with inventory. Do you know what's on your network? Do you know what systems you've got? And so it's a good reference point on how to put together a basic security program. The NIST Cybersecurity Framework was developed after President Obama mandated that our critical infrastructure was at risk. And when you think about it in critical infrastructure, I'm talking power grids, I'm talking water systems, electrical, nuclear. And so they came up with the cybersecurity framework, and it's a category, they've got it set up by these 5 functions, multiple categories and subcategories, and then they map them to the cloud, to the top 20, to the Sarbanes-Oxley framework, to the ISO 2700 and the 800-53. The tool comes with a small application you can run. It's a little database with a context-sensitive panel. And so I clicked on under the protect, and I picked data security, and what I've got were the controls that you put in place for data loss protection to protect the confidentiality, integrity, and availability. So again, we've got that CIA triangle again. And it's got an export function, so you can export it out to an Excel spreadsheet and build your own sort of reference document. The Cloud Security Alliance has a very detailed document that a lot of the material that I'm presenting came from, and it's free, so I would recommend that. They also have a common controls framework where they list 136 controls. They map them across 32 different frameworks, and then they break them out by, again, those architectural references. So you think about the defense in depth, talked about, and where you're at, whether you're a service provider or a tenant or a consumer. So I took that information, I dumped it out into a spreadsheet to capture each of the 32 frameworks, and then I use it to map the control frameworks that we at Tyler are responsible for. The one that I'm just getting into now is a unified control framework, Common Controls Hub. It's a subscription service, but you can get in there and play with it a little bit. You get up to 5 documents that you can list out of the authority document database of over 800, which are basically international and national and domestic. So I picked the PCI, the Cloud Security Alliance again, the Cloud and FERPA, and the FBI CJIS. And I was able to go through, select those 5 documents. It then provides an interface where you can go through and see how the controls overlap. And I pulled out that there's 73 controls that are common to FBI and to PCI. And you can then drill down in to the controls document. And in this one, it's a single control that's dealing with wireless devices and access points. And it maps my PCI requirement to my FBI CJIS compliance. Now, this is a good tool for me because that's an area that our company is in, is the courts and justice space. And I end with my gratuitous hacker slide. We always have to have the guy wearing the hoodie. This is actually a graphic off of a article published by Kaspersky Threat Post about a business called Code Spaces that had built a business on Amazon Web Services. Somebody compromised their privileged account, created some backdoors, held the site for hostage. When they wouldn't pay it, they basically deleted the business. And the Amazon stance was, that's not our responsibility. So again, lower down in the stack, the cloud provider stops, the more security you need to be accountable for. And then I always end with my gratuitous Dilbert slide. In summary, and can we get Catherine's slide deck queued up? You're welcome. See if the just left, right.
Just thinking of something really inappropriate to do with this, so I won't do it. Alrighty. Well, welcome everybody. My name is Catherine Reed. I'm in-house counsel at Unum, where I provide privacy and security law advice. The opinions expressed here tonight are my own, of course. I'm going to talk about the U.S. privacy and data security law framework and highlight some key laws, which I see coming up fairly frequently in the context of procuring or providing cloud services, and talk about some of the commonalities among those laws, and then I will turn this over to Peter Guffin to continue the conversation. So with that, context is very important when offering or procuring cloud services. The privacy and data security legal requirements vary and essentially require a fact-specific analysis in every case. One of the key things to remember is that the legal obligation for privacy and data security compliance largely rests with the procuring entity, if that is the entity directly subject to those laws. In some cases, the laws do apply to both entities, and we'll talk a little bit more about that. The parties can, of course, by contract, impose compliance obligations on, say, the service provider, but in the eyes of the law, the procuring entity is really responsible. So the challenge is, in our legal framework, how to address the privacy and data security compliance needs in the cloud environment where the procuring entity may be subject to a pretty robust body of compliance requirements and in an industry that is heavily regulated, whereas the cloud service provider may not be subject to those requirements And the services being offered may be set up so that they're suitable for use by clients in multiple industries. So what does our framework look like? It's a sectoral framework, and that means that there is no one comprehensive privacy or data security law. So we have a mixture of federal and state laws and regulations. We also have common law privacy principles, such as the invasion of privacy tort, which may come into play. We have many, many regulators, which means, of course, we have many regulations, and then quote-unquote guidelines issued by those regulators, which are important. We also have industry self-regulatory guidelines and programs that come into play. So to determine which of these apply in the cloud services context, we have to look at factors such as what's the industry of the procuring entity? Are we talking about public or private sector? What's the type of data we're talking about? Is it personal data or is it business confidential data? Where do the individuals reside? If we're talking about personal data, what states do they reside in or what countries do they reside in? And in the case of the procuring entity, you also have to think about who your customers are if you're engaging a cloud service provider who will have access to the personal data of your customers. It's a really high-level outline of some of the key U.S. privacy and data security laws that I see coming up in the context of engaging cloud services providers. And what I've done is I've divided them into federal and state categories. Some of them I've listed by name, others I've grouped by type because of the number of laws that fall under a particular bucket. So starting with the Children's Online Privacy Protection Act, and these laws, of course, can come into play in different scenarios, such as when an entity is engaging a cloud service provider to, say, assist with core operations, like data storage, or something more specialized that may be ancillary, such as, say, a toy manufacturer who wants to set up a website directed towards children, the consumers of their product. So, starting with the Children's Online Privacy Protection Act, this is a law designed to protect the online privacy of children under the age of 13. Essentially, in order to collect or use the data of children in that category, the website operator has to get parental consent. The FTC and Federal Trade Commission enforces this really vigorously, and a number of companies fairly recently have gotten tripped up because of failures to obtain the requisite consent, and also setting things up so that kids were able to rack up significant charges online using parents' credit cards without that key consent piece in there. There's a whole, and Peter had mentioned this, there's a whole body of laws protecting the privacy of education and student records. Again, recently there have been a number of incidents where universities have found themselves in an unenviable position of having to defend their security practices after student records were posted online. The Fair Credit Reporting Act imposes requirements basically regarding the use, the collection and use of data pertaining to individual credit. From a privacy standpoint, it requires consent and notice to people in certain circumstances. The Federal Trade Commission Act, Section 5, is significant. Under this section, and again, this is really high level. I'm smiling because Peter Guffin teaches a semester-long privacy course, and so this is attempting to do a fraction of that in 15 minutes. Under Section 5, the entities are prohibited from committing unfair or deceptive trade practices in commerce. While Section 5 doesn't speak to security, doesn't speak to privacy, the FTC uses Section 5 as the basis for pursuing companies it views as having failed to provide adequate security protections to consumer personal data, as well as pursuing companies it feels have engaged in deception in terms of having either no privacy policy or a privacy policy that's inconsistent with what they're actually doing with personal data. while the FTC would say we're not developing case law, a lot of companies look to the Section 5 enforcement actions for guidance in terms of saying, well, what should my security program look like? If you're not going to tell us, we are going to look at the direction you're taking with these enforcement actions. GLBA, you've probably all heard of. This is the law that applies to financial institutions. There's a privacy rule and a security rule. This is why you all get privacy notices once a year from your banks. Under this the GLBA, the security rule aspect of it is fairly general, and the term used is one that Peter had mentioned in his presentation. It requires entities to have appropriate physical, administrative, and technical safeguards in place to protect data. So it's not prescriptive. It doesn't say how. It just pretty much says what. HIPAA. Whoops, sorry. HIPAA. The HIPAA privacy, security, and breach notification rules are a good example of a case where they actually impose direct obligations that can apply to both a procuring entity and a cloud service provider. HIPAA applies to medical plans, healthcare providers, and then their service providers as well. And in 2013, HIPAA was amended. Formerly, it tended to apply only to the procuring entity. However, in 2013, the statute or the regs were amended to apply direct liability to what they call business associates, which are essentially are the service providers. So now everybody has a little bit more at stake in terms of compliance. Marketing, there's a whole body of laws protecting the privacy of consumers in the marketing context. I've added marketing here because many companies, as they seek to engage in more and more online marketing, marketing using mobile channels, are outsourcing this. It's not a core function. There's specialized technology. This is an area where companies are getting tripped up because they're engaging vendors and they're not keeping track of the compliance obligations under, say, the Telephone Consumer Protection Act. Their vendor makes a misstep, and suddenly they're either in the crosshairs of the Federal Communications Commission or they're facing a class action lawsuit. And TCPA is a strict liability statute, so nobody wants to be there. There's a whole body of law governing how the federal government collects and uses personal information. And then I've added law enforcement and national security here, not so much from the standpoint that the related laws are about protecting personal data, but to raise awareness for any entity procuring a cloud service provider, say for any type of data storage. There are laws that, such as the Patriot Act, that empower the government to compel disclosure of data. And so as you set up arrangements, you need to keep that in mind. And then, of course, my personal favorite, the US-EU Privacy Shield, which is a successor to the US Safe Harbor Framework, which was invalidated last fall. This law is one of the mechanisms enabling US companies to transporting data from the EU to the US to comply with the EU data protection laws. And there's a very heavy security component to this as well. So on the state side, where the individual lives essentially drives which state law applies. And so it can get interesting for companies doing business in multiple states, collecting personal data of individuals in multiple states, to assess what the privacy and data security law compliance requirements are, and then map them back to their business processes, including engaging cloud service providers. The California Online Privacy Protection Act protects the privacy of individuals, and again, technically it applies to residents of California, but it has extraterritorial effect because pretty much any company that has a website, if that website is intended for use by folks, including California residents, you need to comply with that. There are 47 states that have data breach notification laws, some of them compelling a response, notice to regulators, or individuals or media within certain timeframes This, of course, becomes important when partnering with cloud service providers who will have access to data, personal data. If that data is exposed, you have to partner with the provider to make sure that you can respond to meet your regulatory obligations in a timely manner. A number of states have laws which impose an affirmative continuing obligation on entities processing personal data to have appropriate security in place. And I call out 3 states in particular: California, Massachusetts, and Nevada. They have some unique laws. California tends to be out in the forefront as far as privacy is concerned, so always worth keeping an eye on. And then the states, not to be outdone by the feds, also have their own little FTC acts, which are used in a similar way by the state attorneys general as the vehicle to pursue companies that they feel have fallen short in terms of having appropriate data security in place, or having that inconsistency between posted privacy policies and then what they're actually doing with personal data. Insurance consumer laws. Under GLBA, the responsibility and the authority for the insurance sector was carved out and delegated to the states. So we have a robust body of state-by-state privacy and data security laws that apply specifically to entities regulated by the insurance regulators. So as an insurance company seeking cloud services, we always have to keep in mind what those regulations require us to do as far as handling personal data and protecting that personal data. And there are enough variations by state that, again, you do have to do a state-by-state analysis. There are state laws regarding marketing, similar to the laws at the federal level. And then there are state laws regarding records disposal that are really, really important. Again, thinking of situations in which companies are seeking to leverage the benefits of using cloud service providers. And in the course of so doing, the providers are either storing or analyzing, processing in any way corporate records, including records that have personal data in them. It's very important to, in advance, decide, well, what are we going to do at the end of this transaction? Or what are we going to do periodically in terms of managing those records, making sure both parties comply with the corporate records retention schedule. I'm giving a shout out to my colleague Mike Marley here, who's a specialist in this area. And at the end of the transaction, what do we do with those records? Anthem, the Anthem data breach, unfortunately, was a good example of what can go wrong when a provider, not necessarily a cloud service provider, but a provider retains records for a long period of time, and then they have a data breach. There's just an enormous volume in terms of providing notice and remediation action. And last but not least, a number of states have laws on the books requiring particular protection for Social Security numbers. Then we have some other influences. There's a self-regulatory framework, which, while it's not law, it's typically considered to be best practices. The frameworks are trusted by the regulators, and the frameworks are enforceable against members. Examples are, as Peter had mentioned, the PCI data security standard. There are 2 self-regulatory frameworks that apply in the online behavioral advertising context. And in addition, the standards, again, while they may not be law, these can become a factor if something goes wrong and a third party, such as a judge, is looking at the facts of a case and the question is raised, well, what security did you have in place? What did you ask your provider for? And if you follow the frameworks and you have those standards in place, it's not an easy conversation, but it's a better place to be. So given this patchwork, what are the commonalities? There's several key pieces to keep in mind. Many of these laws impose an obligation to respect the privacy of consumers. And we typically see this through requirements to provide notice of privacy practices, to get authorization before using personal data, to give people a choice as to whether engage and to allow their personal data to be used, and then to protect the security and confidentiality of that personal information throughout its life cycle. So right through the end of an engagement and the question of how do we dispose of the data or get it back. These laws typically take a risk-based approach to security obligations. They don't spell out the what, they simply provide what you have to do at a high level, and that's where you see repeated, for example, in the HIPAA security rule in the state insurance security laws and GLBA, the obligation to have technical, administrative, and physical safeguards in place to protect data. And last but not least, in most of these cases, the entities directly subject to the laws and regulations are obligated to ensure that their service providers and the subcontractors to those providers comply as well. And this, of course, becomes very important in terms of the risk management process that Peter mentioned, having a risk review process in place, knowing what, from the procurement side, knowing what you actually need before you start to do vendor sourcing. So with that, when we have our panel discussion, we'll talk about some tips for addressing the challenge. And with that, I will wrap it up and turn it over to Peter Guffin.
Thank you, Catherine.
You're welcome.
Yes, just to remind folks, we're going to have a panel discussion following my few remarks here. And that'll be an opportunity for other folks in the audience to get involved as panelists for you to ask specific follow-up questions. I guess rather than hold this, does it work if I just leave it here? Does that work okay? Can people hear me okay? Oh, so what do I need to hold it? Just like this? Is that working now? Hold it up?
Yeah.
Is that good? Is this the thing that is the camera? All right, good.
Well, the camera's over there. Distract.
Oh, the camera's right there. Cool.
But it senses that device.
All right, cool. Well, you've heard a lot about frameworks, right? You've actually heard it in both Catherine's presentation as well as in Peter's. And I don't know if you were counting Peter's frameworks. I started counting them, but I lost count after a bit. And I think you saw in Catherine's presentation that, you know, on the law side of things, we've got a whole number of frameworks as well. Lots of different privacy law regimes. And what's interesting is, to me, listening to both Peter's and Catherine's presentation, is that, you know, this all began actually with the combination of both privacy and computers back in the 60s. For those that have studied the history of sort of the privacy field, you know, you'll understand where I'm coming from. You know, it was the concern in the 60s about mainframe computers, you know, being used by the government to collect all this information about citizens, that gave rise to a lot of thinking from a public policy perspective. You know, giants in this field that began writing about privacy and freedom, Alan Weston being among them, and really, you know, causing us all to think about, gee, we're collecting via this computer lots of information. How do we address the privacy, the civil liberties interests, and protect those of our citizens? And that all had its genesis back in the 60s with the combination of computer and privacy as two concepts. And here we are today, many, many decades later, still talking together as privacy professionals together with computer guys and gals, right? And actually in my practice, I am working side by side continually with technology folks because I need to understand the jargon. In order for me to do my job, I need to ask guys like Peter Higgins, what does that mean? How does that work? And it's important for us as lawyers to understand from the technology folks in this audience how this stuff works, because we can't really do our job in terms of helping clients address their compliance issues, their legal risk issues, unless we know how the technology works. There's no law. You know, you saw a whole host of laws that Catherine put up on the slide dealing with all kinds of different aspects of privacy. As I said, a lot of them have the same genesis in the Fair Information Privacy Practices, which began in the 60s. But they each deal with different sectors of our economy, different aspects of different types of data. But there was not on the slide a law yet that deals specifically with cloud computing. So we can cross that off our list. We don't have to worry yet about a specific law that's been passed by Congress or a state that says if you're a cloud computing company, you've got to do X, Y, and Z, or if you're a consumer of cloud computing, you have to do X, Y, and Z. Rather, we've got all these various laws that we as both technology professionals and as privacy lawyers need to adapt to this environment of cloud computing. And that's really the task I see at a high level in terms of what we do every day when we're dealing with both the legal issues and the technology issues around cloud computing. We're applying these laws to a different platform, a different structure. I had just a few things I wanted to comment on, and actually 4. One is new developments that make this really an important area for us to be working together. One is we've got, as Catherine alluded, a regime in the European Union called the General Data Protection Regulation, which is going to be coming into effect in May of 2018. That law now has a data breach notification obligation that's imposed on anyone subject to the GDPR. Who may that be? That's probably most of us in this room, because if we're working for a business that sells products or services that are directed and sold to a European citizen, then you're governed by GDPR. And the data breach notification obligation carries with it an obligation to notify both the regulator, the relevant regulator in Europe, as well as the citizen, depending upon whether or not certain risk thresholds are satisfied. The fine for not complying with GDPR are huge, and they're getting a lot of folks' attention. Up to 4% of your annual revenues. Yes, that's 4% of your annual revenues are at risk. If you're a Microsoft, if you're a Google, 4% of their annual revenue is a big number. That's got just about everybody's attention. So these violations of the GDPR come with a heavy penalty. What's more, just like in the US, if you are subject to a data breach, you are essentially inviting regulatory scrutiny. That's what we've seen here happen in the US. So that's one major development that I think should cause all of us, whether we're buying cloud services or selling cloud services, when you're talking about data moving around the network, around the globe, at the pace it's going, it should have our attention to address that issue. The other issue I wanted to raise is the Microsoft USA case. And that case involved the ability of US law enforcement to obtain the contents of emails that were sitting on a server in Ireland. And the government sought a Stored Communications Act search warrant to obtain those records. Microsoft resisted, and the Second Circuit Court of Appeals this past July upheld Microsoft's position. And I think it just points out the need for us to be thinking about where is that data located, which country is it located, what laws govern the discoverability, if you will, the production of that data. And I think you'll find that more and more clients are interested in asking that question about where is that server, what's the nationality of the company that's holding that data. Is it a company that's, a U.S.-based corporation like a Microsoft? Do I have jurisdiction over that company? And where is that data at any particular moment in time? Two other quick things. Incident response planning becomes really important these days in the connection with cloud computing. More and more companies are being forced by regulators to look at their incident response planning in the event of a security breach. And that requires both customers and cloud providers to be working together with respect to incident response planning, to know what the drill is, who's going to be doing what, who has which responsibilities, so that the customer can actually comply with its obligations under these various data breach laws. The last point is sort of a worrying one to me. It's the Ponemon Institute, which publishes studies each year on the data breach facts. Reports and studies the facts about data breaches. One of its recent studies talked about the confidence level of insiders, employees who are responsible for incident response planning at various companies around the globe. Their confidence level in the ability of their company's incident response plan to actually be effective in doing the things that an incident response plan is supposed to do. And the numbers were disappointingly very low. 30% felt confident that their response plan was up to snuff. As many of the folks in this audience who deal with this issue know, that's been an increased area of regulatory focus, is having companies spend more time, more energy developing, getting board buy-in, senior management buy-in, testing of incident response plans, and what's more, working with their providers to integrate the incident response plan at both the company as well as the provider. So with that, and those few remarks, Peter, let's turn this over to our panel discussion and start to get some questions generated to this panel. We have an outstanding panel tonight. We have Abby Diaz from Tyler Technologies. I think, Abby, you're the Associate General Counsel, and you work a lot with Peter. And we have, Jeff Northrop from Liberty International. Liberty Mutual, okay. And Catherine is going to join us on the panel as well. And am I missing someone? Anyone else want to join the panel?
I think you're on.
I'm on the panel too. I think I'm moderating the panel. I'm just asking questions. Do we have anyone else? That's it, right? Okay. Can I put this down or should I keep holding it?
Hold it. But sit down. I'll have to pass it around as
All right, so do I get to ask the first question?
Yes.
I do?
You get to explain because you were not at the meeting. You got to be the moderator.
All right.
A unanimous vote.
Okay. So I guess I'll start with asking Abby, it's sort of been on my mind, is how do you help your client, Tyler Technologies, find the right balance in terms of risk in the deals that you're doing with your customers? You're representing the cloud service provider. Your solutions are all software as a service. Peter describes sort of a whole array of level of sophistication of your customers. A lot of them come in like the sixth lineman, not quite knowing what questions to ask. So how do you find that right balance in terms of allocating the risk, helping Tyler walk that tightrope, get the deal done, but at the same time make sure you're not taking on more risk than you should be?
So on-premise solutions in addition to SaaS solutions. So the risk analysis depends on which type of model we're under with the customer that we're dealing with. And I think that in a lot of ways, the risk analysis is something that boils down to a case-by-case situation. You look at the model we're selling, then you look at the products we're selling, and you look at what the customer is asking for. Because when we go into any type of situation, we've got a baseline that we're comfortable operating from. And as the customer complicates that baseline, my antennas go up. Peter often gets brought in at that point, and we have to navigate all of those concerns and questions with, I think, a whole lot more sensitivity. It's kind of the reverse of Peter's slide about the deeper down into the application level, the more increase you need to have in terms of your security and controls. The deeper down the customer is asking us to go in terms of details and expansiveness and extensiveness of commitments that we're making to them, my risk antennas go up. So, in some ways, when a customer kitchen sinks us and just wants to throw it all against the wall and say, commit to us that you comply with all of these things, sometimes part of that kitchen sink is, funnily enough, easy for me to say, okay, because I know that there's no aspect of statutes A through K that remotely touch us. So when I have my goody two-shoes lawyer hat on, I'm irked because I don't want to have in a contract terms that I know never apply to me. But when I have my business lawyer hat on, I think those terms are never going to apply to me. Skip that part of the conversation and let's focus on the ones that cause me some heartburn. So it's that type of risk analysis that I try to do to focus in on the pieces that might rub up against where we play. And then once I identify those, I figure out the parts of those requests that I care about.
Good answer.
I don't know if it was,
Good
but
answer.
it's what the answer is for now.
Before I turn it over to Catherine and Jeff to give us their perspective from the other side of the negotiating table, as procurers of the technology, do you have like hard and fast rules that you have? Like, for example, you might say, that's encryption, that's a customer decision, that's a customer risk. The customer gets to decide whether or not it encrypts its data or it doesn't. And if it doesn't encrypt, that's the customer's risk, and we're not going to, buy into more risk than we should. In other words, for X dollars, I can give you this solution. The kinds of risks you're asking me to assume, really aren't meant for an X priced deal.
I think we do have hard and fast rules that we try to apply, and usually those are business-driven rules. There are certain things that Peter and the hosting team say, from a technical perspective, we do not do this. And then you say, all right, you don't do it now. Is that because you never want to do it, or because you're not getting paid, the customer isn't paying enough for the services provided in order for you to do that? And then depending on what the answer is, we get into a whole new conversation. But there are hard and fast rules where, from Peter's boss all the way down to the interns on Peter's team, everyone says, we don't do this, we aren't going to do this, and you've got to educate the customer for why we don't do it and why it's okay that we don't do it. So.
In my experience, I find that I'm always receptive to a cloud provider that sort of has some clearly defined boundaries. I'd much rather deal with someone who's disciplined about it, in my own experience, as opposed to anyone that's willing to sign anything I give them.
Yeah,
that sort of scares
right.
me because, oh my God, they may not be in business a year from now.
Right. And it's an interesting line to walk, I think, for a vendor in this space where you're talking about data security and privacy, because part of you is tempted to say, I'll sign whatever, I'm your vendor and I'm excellent at every aspect of data security and privacy, and you should totally want to do business with me, and I'm that confident that I will sign up for whatever you want to throw at me. From a sales perspective, that's an enticing bravado to have. But when you got to live up to that type of confidence, it's gut check time.
Right.
And so I think we try to control the conversation to some extent to say, again, this is our baseline. And it's terrific, and it really should satisfy all the things that you need. And then you get into the conversations of the customer saying, but you got to do this, and you got to do it that way, and then the risk analysis game comes into play.
Right. So, Catherine, on the procurement side, when you're, working with a client at Unum that wants to, purchase a cloud service, which I guess is in most of our experience is becoming more and more common. Most of these solutions are now being offered via the cloud. How are you approaching the risk profile? What is it that you're looking to make sure you're satisfied about in terms of getting those contractual provisions and, more than that, really protecting the company, from a risk perspective?
From the procurement side, there's several key pieces. One is to, thank you, John. Sorry. One is to make sure that we understand the transaction. We understand the services that are being sought. Sometimes in a large company, things can get a little bit siloed, and the original business owner seeking the services may transfer the responsibility for actually procuring the services elsewhere. And sometimes there's a little bit of a gap in terms of the communication before we even start to talk with potential vendors. So making sure that everybody involved in supporting the deal understands what we're talking about, what are the services we're looking for, and then understanding whether or not, and this goes to assessing the risk, what data are we talking about? Will this service provider be providing services that will require it to have access to personal data? Whose personal data is it? Because the laws that attach to protect that data will vary depending on whether it's customer data, or is it employee data, is it applicant data, or is it the data of some other category of individual? Making sure we sort through that, and then of course the whole question of, do they actually have to have access to personal data to provide the services? So reducing our own risk again before we even talk with the vendor, and then having the right people who are part of the conversation, and really having an established process for all of this to scope out the deal, to assess what the data is, and then to have a risk review done, and to really know what is required under the law, what's required in terms of the company's risk tolerance, under our own privacy policies and procedures and security policies and procedures, have all of that lined up before you even engage with the vendor. So know what you're asking for and why, so that you don't go in and ask them for the kitchen sink when you don't really need to.
Jeff, is that the same? Is your approach about the same as what Catherine just described?
Yes and no.
Okay.
I think it depends. With regards to the cloud, I provide compliance and security and privacy for global services. So it is classification of the data, how much access do they need, what kind of tools are they providing, how much business is going to run through it. With an understanding that it's likely going to be sensitive, it's likely going to go across borders, it's likely going to be very valuable data from a sensitivity or an intellectual property perspective. Liberty Mutual is not an easy company to sell to. We question the vendors to the nth degree, hundreds, thousands of questions. To get to where they are and what they do, it's fine to say, I'll sign whatever contract you want, but Liberty Mutual wants to know that you can actually do the things you're promising in the contract, and they'll ask questions for it, and they'll want evidence for it. So we'll take them through the ringer. and then we'll check up on them. And it's not just, do they have the security in place? Do they meet all the legal obligations? But on our business side as well, there needs to be assurances that the data they're getting is accurate. We're in a very highly regulated industry. And regulators are asking really difficult questions for the things we are moving to the cloud, but they're not all that well versed in the cloud. So some of them are kind of silly. We'll have multiple availability zones for a product, and they'll grill us on what our backup strategy is. We'll have a complex security model, and they'll say, well, how do you control administrative access? How do you do segregation of duties to deploy code when we have entire platforms that are living as code? So it's usually it's a many month process usually to get a vendor who's dealing with sensitive data into Liberty Mutual. There are always risks, there are always faults with them, but it's not. It never boils down to a contract that spells out that they're going to be able to address or remediate these risks. It's proof that they have these things in place and checks to do so.
Let me turn it back to Catherine and to you just by way of follow-up. Do you think this team-based approach that you have internally at your company and the team-based approach that you have at your company, which I gather includes yourself and lawyers and technologists and others, is that an effective approach to get to this place we're trying to get to, which is a fair allocation of risk in these kinds of deals? Sure.
So let me see if I could briefly describe a project I'm dealing with at the moment. So we have Liberty's embracing Agile at the moment. We're late to the game, but they're just embracing it. We have a product coming out of Australia in our office there that's working in collaboration with a vendor who has a platform that runs on AWS. They launched this multi-million-dollar project effort in September. It's going to go live before the end of the year. So really short cycle. We have Australian and Singapore regulators we need to deal with to make sure that the very sensitive data we're collecting is going to be properly protected. We need to make sure our security controls are in place there because we're transferring the data to the U.S. for processing. We're a U.S.-based company, so general ledger and business intelligence tools. A lot of our security tools will transfer data to the U.S., so we have to have the proper legal constructs in place to make sure that happens. That's kind of the gist of it. So I have privacy people here that I'm dealing with. I have the security team here that I'm dealing with. I have the risk team here that I'm dealing with. I have developers in Australia. I have legal counsel in Australia who's dealing with the regulators there. And then, of course, there's executive exposure. I have to talk to all of those people and get them all on the same page so that they all agree that, okay, in the, I don't know, whatever it is, 12, 16 weeks that we're going to develop this thing, everything is lined up. Without a team approach, that would never happen. And if any individual group tried to do it, they would never cover all the bases.
Do you have a similar sort of a pulling together lots of different team members and somebody managing that process?
We do. We have a procurement department, and they have recently engaged an outside company to provide both services and then software for our use in the vendor. It's both the vendor sourcing, so the risk review process, to provide more structure to what we were already doing, to help us ensure that we have adequate documentation in place of what we've done, so that as different, it's almost like a relay team where depending on, it starts with scoping, the business owner scoping, okay, this is what we want. then it moves to the sourcing phase where they start to do these preliminary risk reviews of vendors. They start the RFP process. And it's all now being documented in the system, which is an improvement in that as it goes through the relay team of specialists, by the time it gets to the third member of that team, they can go back in the system and pull up data and then verbally check in with other members as opposed to a less centralized approach to it. Key members from a risk standpoint, of course, are the information security team members. We work, by the time we get to actually negotiating a contract, they have already done a preliminary risk review and then an in-depth risk review. And again, the level depends on what the deal is and what the data is and what the legal requirements are and our own risk requirements are. I think it's effective. It's not perfect, and I think we're continually trying to improve the process. We want a partnership with our service providers, and that partnership starts before there's ever a contract. So our goal is not to engage in practices that are overly burdensome. It is truly that balancing act, though, and figuring out, I keep looking at Jeff because we both work in highly regulated industries, and there are times where you do have to send that 300-page or 300-item questionnaire to a vendor, knowing that there's going to be a big thud on the other end when they open that one up. But that's the way it works, and by and large, I think it does work pretty well.
So Peter, you've been very quiet there. I'm going to direct this question to you. Given what Abby has said about how she thinks about approaching risk, and how both Jeff and Catherine approach their task from a legal perspective, on the other side, are you working in parallel paths with Abby? So you're sort of doing the answering of the 300 questions that Catherine sent you to sort of work with their security team to sort of make sure that the security team is that sort of your principal focus in these contractual negotiations?
Yes.
Okay. And how does it go when you're so I'm just curious.
No,
so you're sort of talking with the security guys, across the table.
Well, to kind of put this into context, Tyler is not regulated,
Right.
like insurance is. One of my boss's sort of reference points is because we sell to the public sector, we make a case that 85% of the data we deal with is already out there in the public sector. So we're not going to expend a lot of time and energy encrypting stuff that you can get on a town website. And that's where we work with the contracts team to start kind of defining those boundaries. How it sort of evolved was 4 years ago when I took the position, I was the first person. So I had no staff and no budget, and I sat next to Abby's team, and they would come over with these contracts that would have all of this technical alphabet soup in it around CIA and what are the technical, administrative, and controls and all this stuff, and they would just say, what does this really mean and what do I really need to pay attention to? So what we've done over time is work with them. We've created, Abby referred to a baseline. What we did was we took we voluntarily elected to conduct an external audit of our hosting operations, which is the SSA 16. We've conducted the two frameworks, which are the SOC 1, which is the controls around financial systems. And it's because our primary product for Tyler is around ERP systems, so general ledger, financials. And so what we can do is we run this audit, we get a report, and so when the clients come in, now we've got a baseline that we can share with them and say, we're not going to give you all the technical details, but we're going to give you assurance that we've had an external audit and that we're doing the right things. Catherine and yourself sort of alluded to the fact of, in the event there's an issue, you have to have something in place. I make the argument that ignorance is not a defense. You can't say you didn't know. And I make a stronger argument that willful ignorance is even less of a defense, and that you can't just ignore the issue. So we took it to the next level where we conducted the next SSA 16 audit, which is a SOC 2, which deals more around the privacy controls and the integrity controls. And so it's a more of a technical focus. We've taken that information and we rolled it up to what we call a white paper. And again, I'll give a shout out to Andy Smith, who worked with us to do that and basically create a document that is somewhat, it's very sanitized. We're not giving away our technical details, but we're providing a level of information that communicates to our clients that we are doing the right thing for the right reasons and we are paying attention to it. So it's a partnership. It's something that, you know, they can't do by themselves. It's something I need their help with. And what we're doing is we're using this process and we're starting to educate our own internal staff. It's a constant struggle with our sales team, who are very much, you know, their job is to drive purchase orders. And they'll promise the kitchen sink. And then we have to kind of put the reins on them and kind of reel them back in, say, no, you can't do this, you can't do this. And so it gives us an opportunity to kind of start educating them to help them earn the business with a way of, because we are paying attention and we're in concert with our contract folks, we are making a case that our level of maturity is a market differentiator. Because now when we go out to RFIs and RFPs, we can basically make a case that we've got these frameworks in place, we've got staff paying attention to it, and it will stand out when as we're answering these questionnaires. So it's definitely not only a technical issue. It's as much a business issue as anything. So, and I still don't know if I answered your question.
I think so, yeah. I think you hit on something that I wanted to ask about, which is the certifications, right? You know, there's sort of a march to, for vendors, to become certified. ISO certification, PCI compliance. And I'm interested in sort of what your experience, Peter and Abby, has been in terms of how that has helped quell the concerns of customers. It sounds like it has, to some extent, helped. Has it also caused clients to say, I don't need to insist upon auditing you or doing my own sort of review of your this and that? Or you still have some customers who are saying, well, that's nice if you have a third party doing an audit. That's great, but I still want to reserve the right to come in and actually perform an audit.
Okay, so that's one of the hard and fast rules that we have. We don't let our customers come into our network, into our environments and audit us. So another easy answer is I do think that having that report and saying that we're SSA 16 certified nips a lot of further questions in the bud. Often because we can confidently say to them, all the questions you're asking, I can give you a really simple answer to. And here it is, let's move on. So it has been very helpful. And I have even half joked with Peter that I want to get whatever security certifications you all probably have that you can put on your signature block so that when I send emails to customers and they've asked me about a data security or privacy thing, I look a little bit more legit when I tell them no. So yes, I think it has helped.
Yeah. Before we go to the audience, Catherine and Jeff, I'd be interested in your perspective on the importance of the certifications to you as purchasers of the service.
I don't know how much weight the team that vets our vendors holds for certifications. But I do know our large customers, especially corporate customers, want to see a SOC. The credit rating agencies want us to be Sarbanes-Oxley compliant. Of course, the credit card processors that do business with us want us to be PCI compliant. So I mean, you know, those are important for our customers and some of the vendors we use.
So it's a baseline. In order to really get through the front door.
Right.
It
You
really
know,
needs to happen.
PCI, it's just like PCI. PCI is the easy one. Anyone who takes credit cards, the bank is going to require you to be PCI compliant.
Catherine, did you want to add something to that, or have a different view on
It's
the role
it's
of
really
these certifications?
it's really similar. I think our team views them as you know, it's typically a baseline question, and it can help cut to the chase when a prospective vendor does confirm, yes, we have the following certifications. And Abby made a great point about audits, although it's quite common for a procuring entity to request the right to audit. There has to be an understanding that there are limitations. If they are permitted to audit, they can't be given the keys to the castle, because otherwise, you know, the obvious happens. There goes the security that you're desiring to audit.
Right.
Excuse me. So I think we have a question.
And having this third-party certification is a way of transferring risk, right? To a certain degree, I mean.
We haven't really gotten to transfer risk yet. That was going to be the next question.
I mean, because the certification agency assumes some liability, because if they.
Yes.
Has anyone ever been successful in shifting responsibility, liability to the certified entity like ISO or whoever that is? I don't think. Sure.
I was having this conversation actually today with Jock and a colleague about SOC 2 certification, and my understanding of a SOC 2 is that you hire a consultant firm or CPA firm, they come in and they audit you based upon your policies, and they say, yes, you're following your policies. Your policy says you'll do X, Y, and Z, and you are doing that. If you don't, then they tell you about it as a finding. But what they don't do, my understanding is that they don't compare those to like a NIST standard or ISO, and you could, in fact, maybe not use complex passwords. Your policy doesn't say you use complex passwords, and in fact you're not, where it's really a security standard. So you may be doing what your policy says, but your policies are weak, but you got certified. Am I understanding that correctly?
Pass it to Chris.
Got to get more mics.
The first clarification I want to make is that SSA 16 is an assurance audit. It's not a certification. So we sometimes have to make that distinction, where that's what the clients will ask for. The different tiers of audits are, a SOC 1 is exactly what you just said. You know, the SOC, the acronym stands for Service Organization Controls. We asked our auditor where this framework came from. They said, well, it kind of goes back to the days in the early days of banking, when a small bank would outsource the processing of, say, like paper checks to a clearinghouse. So they would go in there and put controls around how they handle, you know, your information and your data. The next tier up, now that was based off of an audit framework called the SAS 70. It was confusing because there was another standard called the trust principles. So what they've done is they rolled in the SAS 70 audit and the trust principles audits into a single framework that all, again, it's a framework developed by the AICPA. So a SOC 2 is more focused around the trust principles. So they are almost along the lines of a PCI audit, say you have to do certain things, and that's what we're going to audit you on. Now the challenge is, you know, they can come in and audit my business at Tyler. They can go up the street and audit another company using the exact same framework, but they're in a different line of business, different staffing model, different securities. So it's not like the PCI audit where there's a checklist of you have to do these 12 things, but it's an assurance audit that we are doing the right things around things like access controls, around user access reviews, around data privacy. So it's a little bit more specific for the SOC 2 audit, which is why we went to that level. Because when we're dealing with, again, a lot of our clients, well, all of our clients are in the public sector. They contract out with third-party audit companies who come in, and they will give them a checklist that say, if you have a financial system that's outsourced to a service provider, quote, or a cloud provider or a hosting provider, and again, it's that whole, alphabet soup of different terms, then we want to see your SSA 16 SOC 1 and your SSA 16 SOC 2. So it kind of speaks to what Abby said. It cuts through a lot of the garbage right up front, because if they're an audit firm and they are a member of the AICPA, they should know and understand what the framework represents. And they will make a distinction between a SOC 1 audit, which is more around, again, exactly what you said, that it's for, we tell them what we do, and they come and say, yes, they grow watermelons and sell lobsters, yes, and they do exactly what they say they do. Whereas a SOC 2 is a little bit more around the technical controls. So it cuts through a lot of the discussion and issues right up front. But, and I'll share this, so I sat at the ISACA conference last week, and one of the questionnaires came up with somebody who used to work at Sage, who's now she now works at a bank up north. I can't remember her name. Pardon? Yeah, Machias. And that was her question was, I can go to one customer, I can basically ask for 2 different types of audit reports, and I'll get an SSA 16 that says, they say they do these 10 things and they do them well and everything's great, and then they do another audit and it's like these people don't know what they're doing and their controls suck, and they can't do antivirus, and it's the exact same business, but it's 2 different audits. So it's incumbent upon the audit firm and the auditee to make sure that they are accurate and they really represent what what you're doing, not to misrepresent anything. So it's a tightrope. So we're treading very carefully.
Yeah. Well, what's interesting is, I thought between Catherine and myself, one of us would talk about the New York proposed cyber regs. But, one of the things that's of interest to me about the New York proposed regs is that it broadens the discussion. So it's not just about personal information. It's really about operations. And it actually is quite prescriptive in a number of different ways, assuming they get passed. I mean, they're out there as proposed regulations right now, subject to public comment. These were proposed by the New York department that's responsible for financial institutions in New York State. But they actually prescribe multi-factor authentication. So they actually get down into the weeds and say you have to have multi-factor authentication. You have to have encryption of data at rest data. So it's sort of an interesting new area in that it's broadened to be looking at the critical infrastructure, if you will, of these financial institutions, imposing an obligation to report any compromise in the operations of the institution in terms of its being able to function, do the things that it's supposed to be doing as a financial institution, whether it's an insurance company licensed in New York or a bank. But it's also getting very prescriptive. It's forcing those licensed entities to actually have these various things, which we haven't seen a lot of. A lot of the standards and frameworks are more generalized along the lines of you'll have reasonable and appropriate administrative, technical, physical controls in place, and leave it to sort of the businesses to figure out what those are, after conducting a risk assessment. So let's move to shifting or actually mitigating risk. Maybe we ought to take the mitigation of risk issue first. Are you finding cyber insurance becoming an increasingly important part of the discussion? So but both from the procurement side, representing a customer, as well as a vendor side selling the solution. Are you somehow, now having to deal with this whole cyber insurance world to mitigate your risk? So in the event something bad does happen, despite having had audits and putting all these procedures in place, despite having all these due diligence inquiries and satisfying yourself that you're dealing with a solid vendor, I think everyone realizes that things happen. People make mistakes. We're not perfect. Hackers can get in if they really want to get in. So how do you deal with cyber insurance? Who wants to take that one? You want to talk that? Okay.
So I don't think we've ever asked a vendor whether they have cyber insurance, but we have cyber insurance, and it's been contentious. How much do we need? What does that look like? How much does it cover? Which has been a really interesting exercise to witness because we actually sell cyber insurance as well. And I don't think the underwriters who are selling the cyber insurance helped with the particulars of our cyber insurance deal. I think they were consultative, but I don't think they could value it. And I don't really get involved with it. It is a Liberty Mutual wide cyber insurance policy. I do know that the people who actually calculate the risk for the insurance we sell are some of the most skilled people. We have crunching numbers because it's so unknown. The company dates back to the 20s, I think. You would probably know better than I would.
1912.
There you go. So there's all this data on all sorts of insurance we sell that they can run the numbers on, and actuaries do a job and calculate the risk. Cyber insurance changes all the time. Every time there's a breach, it seems like there's something new going on with it.
I just want to ask Jeff on that subject, if you find that when you're presenting to a customer, if they have a hard time, if they invest their money in tracking, watching, and dealing with folks, actors on their networks live, rather than paying for what can be a very expensive proposition, right? To be able to say, this is what we're going to try to cover with our cyber insurance plan. The deal is so fast. You get that kind of come back in terms of making a business case to sell the insurance versus.
Are you asking whether we assess the company we're going to insure before we insure it?
No, I'm saying, is the sales pitch difficult to make in the light of the fact that so many companies already have threat on the network? So spending money in that realm versus buying an insurance policy that could or could not end up covering them in the case of.
I don't even know who in Liberty I could ask that question.
Yeah,
It's too big. I don't know. I wish I had. It's an interesting question. I just don't know. I don't have an answer.
Catherine, are you requiring that of your vendors? Are you asking whether your vendor has cyber coverage? So it can stand behind some of the things that it's promising to do with the contract?
Depending on the circumstances, we may ask for that. We also have our own customers who on occasion inquire, when we're going through an RFP process with a customer, they may inquire if we do have cyber insurance. So it's sort of a happy circle in that regard.
And Abby, how about you on the vendor side? Is that something that you're getting increasingly asked about? Are you having to sort of demonstrate to your customers that you have some form of cyber coverage?
Yes. Yes, we have cyber liability insurance. We get asked about it a fair amount. It's not one of the top ticket items that we hear about, but we have it, and so it's an easy question to answer. And because of the type of services we provide, our professional liability policy also dips into protecting us on some of these types of events. The things that are actually harder for us as the vendor when it comes to risk mitigation is reassuring our customers how we are vetting our employees and how we're training and kind of tracking compliance within our employees. So actually one of the hardest things for us to deal with are background checks and fingerprinting, which get asked for with increasing regularity. Like even just a year ago, those types of requests would only be made for on-site implementation teams. Within the past 12 months, the frequency of requests for the folks in the hosting department or the hosting team to get fingerprinted and background checked for every single customer we sign into our SaaS model. So that's a lot of customers on an annual basis to open the floodgates on and tell Peter every other week almost he would have to be getting rechecked and re-fingerprinted. So that for us is the hardest thing to navigate.
I just want to do a quick time check.
Yes.
I have that it's a couple of minutes before 8. I think
Oh, yeah,
these
we're
clocks are a little slow.
Right.
So out of respect for everybody's time, I just want to
No,
check
thank you.
in.
I was looking at that clock, and you're right. It's 10 minutes.
happen to glance.
Why don't we? Any questions from the audience that if we haven't covered something that you're dying to get an answer to? Now's your chance. Go.
I know that the laws in Europe are different. One of the aspects of the laws in Europe that I find really interesting is that the privacy laws give an individual rights to make claims against organizations that may have abused or mistreated their information. Do you see that ability in the law here on U.S.-based law, or do you think that will be something that will be coming? Individuals having the ability to make a claim for privacy abuse.
Well, there is that right today, and people bring class action lawsuits. You know, in the event of a breach of privacy, they bring either on behalf of a class or themselves individually actions for negligence. They could, under many of these state, Catherine talked about the mini FTC acts. There are private rights of action you can bring under that for deceptive, misleading acts, by a wrongdoer, the person that you're suing. So yeah, there is already here in the U.S., avenues for relief for private individuals. That said, a lot, there hasn't been a lot of success in that area by plaintiffs here in the U.S. In bringing those suits. In large part, it's because of standing issues. Plaintiffs who have been the victims of a data breach have a hard time getting the threshold issue resolved as to whether they've had injury, a concrete injury in fact that allows the court to take their case from a jurisdictional perspective. So the standing issue stands in the way of a lot of these plaintiffs' attempts to seek redress for these. But that is, constantly under. I mean, there's a lot of very talented, very creative lawyers out here who are trying to find theories to bring to courts to get relief for individuals who are affected by these privacy breaches. One thing we didn't talk about, and Catherine, as the other, and Abby as the lawyers here, if you have a different view on that, I'd be interested in hearing your view. But I see some of these standards. There's a case in Massachusetts from a few years ago involving an insurance agency where the individual was harmed because of a privacy violation, brought suit under the Massachusetts info privacy statute and reg, had no private right of action to do that, so the court threw that out. But because the plaintiff alleged that the insurance agency did not follow the access use rules under Massachusetts regulation, that was enough to allow the plaintiff to go forward on a negligence claim. So a lot of times these statutory standards that are baked into these various legal regimes become sort of create a negligence standard, create a duty on the part of in this case it was an insurance agency as an employer who was obligated to only give employees who had a need to know access to the systems that contain the personal information of this particular individual who was harmed. And that was allowed to go forward as a theory. So Abby and Catherine, do you want to add anything to that on the private right of action of individuals?
No, I think you've captured it.
Well, regulatory enforcement is, where the action is here in the U.S. today. You have very aggressive state AGs, very aggressive Federal Trade Commission, increasingly the OCR, which enforces the HIPAA rule. So I think most of us that practice in this area are more, we're obviously concerned about litigation risk, that liability risk. But I think the real activity that concerns us is the regulatory enforcement, because you have not only the reputational loss, but also the enforcement action, the corrective action plan that you may become subject to. So.
I have what's hopefully a quick question.
Okay.
Who knows? If you are a small business wanting to become a subcontractor vendor to these companies who are being held to these various regulations, is there a source where you can go to find out what are all the federal regulations and state regulations and security board regulations that you need to get your house in order with before getting into that space? Is there a reference? The laws change. How do you know what the latest rules are?
Yeah.
Is there a source?
Abby, Catherine, you want to take that?
I think if you are looking at a certain industry as your potential customer base, then engaging with, for example, there are insurance trade associations whose services include monitoring laws applicable to their members. So that's a good place to start in terms of saying, well, if I want to provide services to insurance companies, what laws apply to them? And by virtue of that, extrapolating what you need to be thinking of as you structure your security. There are also more general legal resources, I guess, as well. And then I'm also thinking of the information Peter provided as far as security standards. But I'll pass the baton.
I can't wait to hear it. I want to know where to go to get my source.
Well, one of the benefits of being a member of the IAPP is that
I was going to make a plug.
they have resources at the organization, and they also have a listserv. And I sort of have emails that come by every day where somebody, and these are all the legal professions, and they put out a question. Hey, I'm dealing with this particular nuance requirement. How do you guys deal with it? And then you get this sort of response, this thread of people globally who are answering and have already encountered that problem, who are also having that problem. And so it's basically just tapping into that community. And one of the other answers that we use with our RFIs and RFPs, where they come in and say, the clients will ask, what are the legal requirements about, how we need to deal with FERPA, the Federal Education Privacy Act in the state of New York, which is becoming very stringent. And we basically have to turn around and say, hire a lawyer. We are not in the business of providing legal counsel. So, there are people out there who can help you. But I would start with the IAPP, become a member and tap those resources, because that's what they do.
What a great way to finish. Thank you. Thank you for that plug.
And on behalf of Justin Clark, our chapter president, and the we do have a small but suitable for framing gift for each of you. Some of them have a little bit of dirt on them.
Barbecue sauce.
So thank you very much. Ironically, Peter is a signatory on his own certificate. That's kind of funny. Thank you. I might have gotten this on my document.
Thank you, Chris.
Thank you all. And I want to let everybody know, too, that our next meeting is the 9th of November. We'll be talking about an exercise that happened this spring at a National Guard base with our own Eric Bryant and Andrew Sylvia and a gaggle of Army and Air National Guardsmen. So we do welcome you to come back to that. Unless there's anything else.
CPEs?
CPEs, yes. If you haven't hit the sign-in sheets, please remember to do so. Thank you all very much.
Thank you. Thank you.